everyone, and welcome to the first of two videos on tort defences. Today we're going to be looking at Volenti non-fit injuria, and in the next video tutorial we'll be looking at contributory negligence. But today it's Volenti. Volenti non-fit injuria is a defence of limited application in tort law. A direct translation of the Latin phrase Volenti non-fit injuria is to one who volunteers, no harm is done, or it's sometimes said as no harm to he who consents. And where the defence of Volenti applies, it operates as a complete defence which absolves the defendant of all liability. See that the principle behind this defence is that if the claimant has consented to behaviour that carries a risk of harm, then the defendant is not liable in tort. And we have touched upon this when we've looked at OCCUPIER'S liability, and we've looked at Tomlinson and Congleton when he was ignoring warning signs not to jump into a lake. And we said at that point he was Volenti. So today we're going to be looking a bit closer at the requirements of the defence. The defence of Volenti non-fit injuria requires a freely entered and voluntary agreement by the claimant in full knowledge of the circumstances in order to absolve the defendant of all legal consequences. There is a considerable overlap with contributory negligence, and since the introduction of the Law Reform Contributory Negligence Act 1945, the courts have been less willing to make a finding of Volenti, and they prefer to apportion the losses between the parties using contributory negligence rather than taking the all or nothing approach with Volenti. So just be mindful of that, and that could come up in an evaluation essay on exam 3, that yes, Volenti does exist, but the courts are more willing to use contributory negligence now. But in order to succeed with the defence of Volenti, the requirements are that the claimant knew of the risk and they voluntarily accepted that risk freely. So we'll have a look at the first case that illustrates this, Morris and Murray. You can see here that the claimant and defendant in this case had been drinking all day, and the defendant, who had a pilot's licence, had a light aircraft as well. He suggested that they took the aircraft for a flight. The claimant agreed and drove them both to the airfield. They started the engine and the defendant took off, but he crashed shortly afterwards. The defendant was killed and the claimant was seriously injured. An autopsy revealed that the defendant had consumed the equivalent of 17 whiskies. In an action for negligence, the defendant raised the defence of Volenti non-fit injuria, and the defence was successful. And the court said here that Volenti was allowed because the actions of the claimant in accepting a ride in an aircraft from an obviously heavily intoxicated pilot, he'd had 17 whiskies, it was so glaringly dangerous that he could have been taken to have voluntarily accepted the risk, and he therefore waived his right to compensation. I think in that case, it seems fair enough. But this leads us on to considering other situations where someone's a passenger in a car. Now, obviously, this was a passenger in an aircraft, but what I want to consider now is passengers in vehicles. And the courts have been reluctant to allow Volenti in cases of negligent driving, even where the passenger has got in with an intoxicated driver. And if you look here, we've got the Road Traffic Act 1988, section 149, states that contributory negligence should apply where a person accepts a risk by getting in the car with a drunk driver. So in other words, nowadays, if your claimant gets in the car with a drunk driver, rather than using Volenti and saying, okay, they're entitled to nothing because they took the risk, what we'll say is, okay, they took a risk, so they were contributorily negligent, and we will reduce their damages in accordance with their own stupidity, if you like. So just be aware that if you're getting in the car with a drunk driver, it's not going to be Volenti, it's going to be contributory negligence now. Volenti is important in relation to sport. A participant in sporting events is taken to consent to the risk of injury, which occurs in the course of the ordinary performance of the sport. And that shouldn't be surprising to us, given what we know of the criminal defence of consent from our study of criminal law. So that rule comes from Condon and Basie, that you are consenting to run the risks that are ordinarily associated with that sport. However, it's important to compare the case of Condon with Smolden and Whitworth. In Smolden, our claimant was 17 and he was playing rugby and suffered really serious injuries when a rugby scrum collapsed, and he actually broke his neck. Now, the defendant was trying to argue that he was Volenti, that this boy had consented to the risk. But the judge looked at the situation and said, okay, he's 17, so he's a child, and the rules of the game for children are slightly different, and there are special provisions in relation to the scrum. And the person who was enforcing the safety rules wasn't enforcing the special scrum rules. So the court said that Volenti didn't apply. So Volenti won't apply where the officials are not enforcing the rules of the game. And so that was outside of the rules of the game for young players. As I've already mentioned, we have come across Volenti with occupiers' liability. So it might be that if you're doing a scenario on occupiers, you need to consider in that scenario, could they possibly plead this defence? So just to remind you of Tomlinson and Congleton again, Tomlinson in this case ignored clear warning signs which said, don't dive in the lake because it's very shallow. And he did dive in the lake anyway, and he was left tetraplegic. And in this case, the defence of Volenti was used. So the council were not liable under the Occupiers Liability Act 1984 because our claimant had volunteered or consented to the risk. And the risk was said to arise from his own voluntary action rather than the state of the premises, the state of the lake. The risk was obvious, so the claimant was Volenti. In terms of evaluation of this defence, you would have to put it in with contributory negligence because the two overlap. But just before we do our contributory negligence video, I'll just pull out some key points. Remember that Volenti is a complete defence, it's all or nothing, so that can be very harsh. And for that reason, the courts are now very reluctant to allow a defence of Volenti, although of course they did in that case of Tomlinson and Congleton. It can be slightly confusing whether someone was acting voluntarily. Some judges are of the opinion that there must be an express or implied agreement. If you think about Morris and Murray, that seemed very fair on the facts, but there might be cases where the facts are not so clear-cut, when the person isn't so obviously drunk, etc. Remember also that the Road Traffic Act has limited the Volenti defence, so that if you get in with a drunk driver, that's now going to be contributory negligence. Okay, so we will leave Volenti there. Please watch the next video tutorial on contributory negligence.